in the matter of petitioner Charles Paul Nerswick versus respondent Lindsay Ann Dineski. Ms. Dineski, please state your name for the record.
Lindsay Dineski.
Please raise your right hand. You solemnly swear to affirm any testimony you provide to the court today will be the truth and nothing but.
Today we're diving into a courtroom showdown where sovereign logic crashes headfirst into real-world consequences. Lindsay Dineski, a self-styled legal guru, kicks things off with a dramatic oath, then instantly sinks her own credibility by declaring the court has no authority over her. She claims the warrant is invalid because it wasn't handed to her personally, conveniently ignoring that she moved without telling anyone. The judge tries to steer her back to reality, but Lindsay's already in overdrive. Her strategy? Filibuster with buzzwords and flood the room with sovereign speak. It's pure courtroom chaos, and we're just getting started.
Service on that. I was never given any service on that warrant, so it's invalid.
So the warrant issued because you failed to appear
For a court that I never received any service on.
for the show cause hearing. I do see that proof of service.
I was in another state, so there's no way I received any proof of service, and you guys had my email and my phone number, and nobody ever contacted me, so this needs to be thrown out immediately.
No, that's not how the court.
Yes, the law says. The law says if I do not have proper service, it's an invalid warrant.
Lindsay doubles down, proclaiming that the court has no jurisdiction over her living being, practically one step away from declaring herself a sovereign island adrift from the law. She touts her status as a secured party creditor as if it grants immunity from warrants, arrests, or court orders. The judge calmly explains that jurisdiction isn't a matter of spiritual alignment, but Lindsay plows ahead with a torrent of pseudo-legal jargon. It's like watching someone insist gravity doesn't exist while tumbling off a cliff, loud, wrong, and utterly committed.
Okay, Miss.
We had a trial on this matter because I've never been able to present any evidence.
Be quiet.
This is my hearing, and I'm allowed to speak at my own hearing.
I have to let you know I'm arraigning you.
You're reading it on an invalid warrant. This needs to be dropped immediately. Is this an Article 1 court or an Article 3 court? Because if this is not an Article 3 court, you have no right to adjudicate anything to do with my liberty interests. And my children are my liberty interests, and they are my offspring, and this man attacked me, so this entire PPO is based on fraud and is void. So that not only can you not arraign me, but you need to overturn the PPO immediately.
So, Ms. Dineski, you were served on October 23rd, 2023. There was a show cause hearing for a violation of the PPO that occurred on December 4th, 2023. Just for the record, I have muted Ms. Dineski because she refused to be quiet.
You're not allowed to mute me at my hearing. Is this an Article 3 court or an Article 1 court, ma'am? You have to answer me. Are you an Article 1 judge? Because if you are, President Trump said that you are not allowed to hear anything to do with my liberty interests in his executive order that he recently put out.
All right.
Are you Article?
Is that you stopped Mr. Nerswick's mail? You were interfering with his mail, Ms. Nerswick, and wasn't able to receive his mail.
If you do not have a constitutional oath, then you have to recuse yourself immediately and let me have an Article 3 judge, because this has to do with my constitutional rights. And Article 1 judges.
So the court is in receipt of a customer information form that
You do not consent to this PPO, and you must prove and show your oath.
USPS at an address of 18337 Ewell Road, Belleville, Michigan.
I was not living there. I had been evicted from there previously in June, so there was no proper service.
The petitioner filed a motion complaining that you, Ms. Dineski, stopped his mail.
I didn't stop anybody's mail. He came and stole my mail and signed for a certified letter that he sent me, so I didn't receive it. And you guys won't let me show evidence This has been going on for over a year, and I've never once been able to show evidence, and I've demanded a trial multiple times, and you've denied me a trial. So you're going to be going to prison under USC 18, 241 and 242, and I'm going to be asking.
Lindsay's meltdown shifts into overdrive as she begins openly questioning the court's very legitimacy. She demands every document be certified in wet ink and refuses to recognize the name on the case file. Ordinary procedure, to her, is some grand conspiracy ripped from the Matrix. The judge stays calm, giving her space to speak, but it's obvious she's confusing patience for surrender. At this point, sovereign citizen ideology slides from delusion into outright disruption. It's no longer about rights, it's about hijacking the process, and the tension in the room is rising by the second.
Bill of Pain and Penalties, which has been outlawed by the Constitution, Article 1, Section 9, Clause 3. You are using an unlawful PPO to withhold me from my offspring, which qualifies as kidnapping and hostage taking and treason and torture. And this matter is void ab initio from the beginning because it's based on fraud, and fraud vitiates everything. Marbury versus Madison, anything repugnant to the Constitution is void. This is a violation of my free speech. This is a violation of my right to petition the government for redress of grievances. It's a violation of my Second Amendment because you said I couldn't have a weapon or bear arms.
Ms. Stanowski, I'm going to put you in the breakout room with Ms.
This is a violation of my Fourth Amendment. This is a violation of my Sixth Amendment. This is a violation of my Seventh Amendment. This is a violation of my Eighth Amendment right, my inalienable Eighth Amendment right. This is a violation of my Ninth and Tenth Amendment rights. You are violating all of my rights, and I have not ever been allowed to be heard. Due process allows me the right to be heard, and this has been ongoing since 2023, and I have never had the right to be heard. And I've had my babies unlawfully held from me based on fraud, which I never got to present evidence to.
Lindsay escalates further, accusing the judge of violating her rights, obstructing her process, and conspiring against her supposed sovereignty. She's no longer defending herself, she's waging war on the entire judicial system. Citing Article 4 of the Constitution and even the Magna Carta, she stitches real documents together with fantasy law. In her eyes, the courtroom has stopped being a courtroom and become a battlefield for her ego. What she doesn't see is that every rant digs her hole deeper. And the judge? He's done being amused.
Prosecutor, I'm putting this over. I want to reconvene at 2 o'clock.
I'm demanding a quo warranto.
All right. Deputy, did you hear me? Officer?
Your Honor, I do have a 2 o'clock. Did you want me to come back? I have a 2 o'clock in judgment.
I don't need an attorney. I don't consent to an attorney.
Yeah, I can't. I don't have a prosecutor. I need you to come back. What about 2:30?
I want to say something. You guys are.
Your Honor, I'm talking to
5 days.
I have no prosecutor.
I was not even notified of this court. I was not even given notice of this court date, and I've been here.
So let's say 1:45. I don't have a prosecutor.
You need to be quiet. This is my hearing.
Can we do 1:45, officer?
Yeah, 1:45.
Okay.
All right, we'll see y'all back at 1:45.
Okay, thank you, Your Honor.
I do have one question.
Go ahead, officer.
Just for staffing purposes, can you give a time, because that's right around shift change, do you think that hearing would be done by 2:30, or are
I'm waiting on the prosecutor. I can't.
Well, it has
The
to
record is
Your Honor,
going
I have
now.
a 2 o'clock.
I can't call it. So
Prosecutor, I'm asking for this to be
Okay.
dropped.
yeah, 1:45 is the time that I have.
Why won't you
Okay.
answer any of my questions?
Your Honor, I'll see you at 1:45. Thank you.
Lindsay shifts from belligerent to full-on theatrical. She demands the judge identify himself for the record, questions the authenticity of the court seal, and insists the entire proceeding is a sham. She's not engaging in legal argument, she's staging a performance. This is textbook sovereign citizen theater. Talk fast, spout nonsense, and hope the court buckles under pressure. But Judge Shackelford isn't new to this act. He lets her talk herself into a corner, and you can almost feel him readying the gavel for the final drop.
About prosecutor's office, but
I kind of thought so. I did start, but for this particular one,
Yeah, this one I think.
considering the fact that,
yeah,
I've been we needed you here. That's why I started off, and I was like, oh no, that's it.
Leslie, as far as the allegations go, I do believe that this is a bench warrant arraignment.
Hold on. Yep, it is. Let me start to call the case. All right, CJC, are you there? I want to call the case, but I want to hear from you.
Yes.
All right. All right. Thank you. Let me call the case.
Recording in progress.
This is case number 23-104850-PP in the matter of Charles Nurswick versus Lindsay Ann Dineski. Mr. Tudge, if I could get your appearance from the prosecutor's office.
Good afternoon, Your Honor. Gregory Tudge, B85961 for the people.
All right. Miss Fort Williams, your appearance, please.
Good afternoon, Your Honor. Gail Fort Williams, P35963, counsel on behalf of the.
All right, Miss Fort Williams, you had an opportunity to speak with Mr. Dineski in the breakout room.
Why is there still an attorney on my case when I said I don't want one?
I attempted to speak with her, Your Honor.
I do not want or need an attorney.
All right, Miss Fort Williams, I just want you to stand by at this time, if you can do that.
And I'm entitled to relief from judgment under Michigan Court Rule 2.612 because I was not personally notified of this matter, and so it needs to be dismissed immediately.
Ms. Dineski, you were arrested for a warrant issue because of your failure to appear.
A failure to appear on something I was not personally notified on, so under Court Rule 2.6123, not personally notified, I'm entitled to relief from this proceeding and action.
Okay, let me hear from Mr. Tudge. Go ahead, Mr. Tudge.
Your Honor, it does appear that 2.512, I believe, was the citation. Which 2.516.
I'm sorry, 2.612.
Chapter 2 of the Michigan Court Rules governs the civil procedures. This being a quasi-criminal matter,
This is a civil procedure because it's family court.
Hold on, Miss Dineski, let Mr. Tudge speak.
It's not quasi-criminal, this is civil.
All right.
So that's a twisting. This is a family court matter.
Miss Dineski, please let Mr. Tudge speak first, please. Go ahead, Mr. Tudge.
I thought this was my hearing. I should be the one speaking.
Things turn even more surreal. Lindsay demands the judge prove jurisdiction on the record, as if she's the one running the trial. She claims she's appearing under duress and refuses to acknowledge any authority in the room. Her voice rises, her arguments grow more erratic, and her faith in her imaginary legal armor takes on an almost religious tone. This isn't just defiance anymore, it's doctrine. But courts don't run on belief, they run on law. And Lindsay is crossing the line from disruptive to contemptuous, with the court's patience about to snap.
MCR 2.612 does appear to be governing civil proceedings. This matter being a quasi-criminal proceeding does and is controlled by the court rules which address misdemeanor offenses, unless otherwise stated in Chapter 3 under special proceeding. I do believe that the cited rule is inapplicable for this proceeding.
You may proceed.
I'm sorry, I didn't hear him. Did he say applicable or inapplicable?
It is applicable, Ms.
Oh, okay.
Okay, go ahead.
Your Honor, I must correct the court. The argument is not applicable, inapplicable.
Oh, he said not applicable.
Why would it be inapplicable?
He's saying the court rule your side, his position, and I agree with him. Let me just say that for the record, that the court rule your side governs civil procedure. It doesn't govern under quasi-criminal matters.
This is not a criminal matter. This is a civil matter. It's a domestic matter. How is that criminal?
Ms. Dineski.
And in criminal procedure, it's the same thing. These also, the criminal code also.
Dineski,
the reason why I looked up this.
I'll give you an opportunity to speak, but I need to hear from Mr. Tudge first.
But it's my hearing. I should be heard first.
No.
This is my hearing. I'm the one who's supposed to be heard, not the prosecutor.
But they're being heard because you're violated a PPO.
I didn't violate anything. I was not notified.
Sorry,
of
the
anything.
allegation that you violated a PPO.
Okay, well then I have a right to say I was not notified.
I'm going to give you that opportunity, but you have to. The allegation is that you violated a PPO. You have to let the prosecutor's office, the representative of the attorney from the prosecutor's office, speak. Go ahead, Mr. Tudge.
Your Honor, I don't believe I have anything further as to the argument. As it relates, I would ask that the arraignment for the bench warrant continue, and I would also ask that the court inform the respondent of the standards for which respondent will be held if proceeding pro se, and I believe it would be appropriate to.
I'm proceeding sui juris and persona.
Well, I am going to ask Ms. Fort Williams to operate.
No, I don't want an attorney. I do not
and
want
my
an attorney.
Ms. Janeski, I have acknowledged the fact that you are not wanting an attorney.
No, I refuse it. It's not that I don't want one.
I have Ms. Fort Williams to stand by. She's just going to stand by.
Even though I
What else would
appreciate
you like to say, Mr. Tudge?
I believe it may be of benefit for the court to voir dire or Attorney Williams to voir dire respondent as to a right to have counsel and whether respondent knowingly, intelligently, and voluntarily waives the right to counsel.
All right, Ms. Janeski, you understand? Go ahead, Ms. Fort Williams.
Your Honor, I just wanted to say, Ms. Daneski was speaking about being served with the violation, and she's indicating that she was not served. She may have been quoting the incorrect court rule. I don't know. I don't have the court rules in front of me. It doesn't matter, though. Either way, of course, anybody in court has to be served with the appropriate papers. What she is indicating is that she was not served. And I indicated to her, but I don't think she was listening to me because she was talking and I couldn't talk. I indicated to her that this is an arraignment and that she will have the opportunity to address service or lack thereof, if that is the case, when a trial is set or whatever is set.
No, according to versus McVicker, I can challenge this at any time.
Your Honor, Mr. Daneski, you have to be quiet. For purposes of what she was indicating, Your Honor, it is true that everyone has to be served. I don't know about that court rule, and it doesn't matter whether she's quoting all these rules. It doesn't matter. She's indicating she wasn't served. That's all. Thank you.
Thank you. But the thing is that it doesn't matter if this is an arraignment.
The courtroom finally hits a breaking point. Lindsay accuses the judge of impersonating a public official and starts reading straight from the Sovereign Citizen playbook. She tosses out terms like color of law, malfeasance, and trespass on the case, none of which apply, but she's convinced they do. At this stage, the judge's tone shifts, still calm, but clearly done humoring her. You can feel it. Her performance now carries real consequences. She thought she was above the law, but the judge's patience isn't endless. Lindsay's window for reason has slammed shut.
Your Honor, it's indicated, I believe in the court record, a proof of service has been submitted. If there are further questions as it relates to service, and ultimately it may be, however, I leave this to either respondent or if respondent wishes for an attorney, respondent's attorney to address that if there is a request or motion to have the court issue a summary judgment as to the alleged violation, the burden of proof would be on the respondent to do so.
All right. It would not be. The burden of proof is on the one who would process the service. I was out of state when this hearing was set up.
I do show that a proof of service was filed for notice of hearing for the show cause that took place on December 4th, 2024 by the attorney that was representing Mr. Nurswick.
So where did he serve it to? Because I wasn't even in the state of Michigan. I was living out of state at the time, and you guys they have my email, and they never even emailed me. They have my phone number, so I wasn't notified by phone, email, or mail. So if they served it to the Elwha house, Chuck is the one who signed it, which is fraud. He has been defrauding the court since the
So
beginning of this.
There is a proof of service in the file that was filed on November 8th, 2023, that a notice of hearing for the show cause on December 4th went out. Have you, Ms. Fort Williams, talked to your client? How would you like to enter a plea on her behalf? What plea?
No, I do. She doesn't need to enter a plea on my behalf. I said I don't want an attorney. Why do you keep going to her? I want to speak for myself.
All right, let me say this. Ms. Dineski, you've been advised of your right to have counsel. Is that correct?
No, I have a right to assistance of counsel.
All right.
Okay.
Do you want assistance of counsel, Ms.
She can assist. She already told me her opinion, so I appreciate that, and I'm competent to speak for myself now. But I do appreciate her very much.
So you asked for the assistance attorney, Ms. Fort Williams.
No, I didn't ask for it. She gave it to me, and I accepted her opinion. But I don't. The law does not agree that I can't ask for this to be dismissed in an arraignment, because Lufkin v. McVicker
So
said
your
that.
request for dismissal is denied.
Why?
And Your Honor, I would ask.
And you have to. I'm also.
Hold on, I need to hear from Ms. Fort Williams.
It's my attorney speaks. Why do I get to speak?
Hold on.
Your Honor, I asked that a plea of not guilty be entered, and I'm asking that she be given personal bond. She is a resident of Detroit, Your Honor, and she's been incarcerated since the 13th. And I'm asking that she be released on her personal recognizance. Thank you.
Because I'm living locally. If I knew there was a court hearing, I would have been
Mr.
there.
Judge, if I can hear from you, please, as it relates to bond.
Your Honor, as it relates to bond, I did have the opportunity to speak with the petitioner prior to today's hearing. It's my understanding that there has been numerous instances of contact with the contact from respondents beginning on or around December of 2022, which I understand predates the personal protection order, this being when unwanted contact is alleged to have began, and the last instance of unwanted contact on or around February of 2025, just 5 weeks ago is what I've been informed of. I would, given both the allegations of contact and the information of continuous contact, as well as respondents' failure to appear for the prior proceeding, I believe was set for a bench trial, it does appear that there may be a concern of respondent attending future court hearings. And as such, I would argue that a GPS tether would be appropriate for both the security of the public and petitioner, as well as securing the respondent's future attendance at court proceeding.
All right.
Do I get a chance to speak on my own behalf?
I'm going to give you that chance. Ms. Dineski, are you incarcerated for any other matter?
Yeah, I'm incarcerated, falsely arrested, because I asked to talk to a supervisor when I was pulled over in River Rouge, and they beat me up and pulled me out of my U-Haul and beat me up and arrested me and put me in a dungeon for...
Lindsay now flat out refuses to answer direct questions, tries to dismiss the judge from the case, and even threatens a federal lawsuit. She's emptying the last rounds of her sovereign arsenal, but instead of scoring a victory, she's collecting warnings. The judge spells it out plainly: stop the nonsense or face the consequences. Yet Lindsay won't budge. For her, backing down would mean betraying her ideology. For the court, it's the only path to restoring order. The gap between fantasy and reality has never been wider, and Lindsay keeps sprinting straight into the void.
This PPO, since the beginning, ma'am, I have been telling you that this needs to be dismissed. I have not had my chance to put any evidence in. You unlawfully dismissed the PPO that I had against Charles Nerswick, and then you went ahead and reissued a PPO right after you dismissed the one that I had against him, which is unlawful. You dismissed the original PPO against Charles Nerswick that I had after he admitted to trying to run me over. I'm talking now. It's my turn to talk. Let me talk.
What is your bond on the felony case? You're charged with a felony right now?
I am, unlawfully. And I'm already getting a tether, so it's a moot point.
So what is your bond on that case?
$10,000.
That,
And I'm going to be asking for a bond reduction.
all right, so
I'm not even going to be getting out anytime soon anyways. But my point is that this needs to be dropped because I've never been able to show evidence. And on my
a $10,000 cash surety with tether?
Yeah, with a 1% or 10, whatever, I have to pay $1,000 to get out.
Okay, so it's 10,000, 10%?
I guess, yeah.
With
Your Honor,
With a tether.
Go
So
ahead.
the thing is, but my point is, I would like to speak on my own behalf about this PPO, because you dismissed, you need to recuse yourself because you have violated my rights from the beginning of this case. You did not let me show evidence in my original PPO case, and you dismissed the PPO when I never had a chance to have evidence. And that man, Chuck, who kidnapped my babies from me, who has never even been found to be the biological father of these children, lawfully. The thing is that you dismissed. You said I could have a chance to talk. Please let me state my case.
Mr. Tudge would like to speak at this time. Go ahead.
It's my turn. You said I could have it, and you keep letting them speak, and you will not let me speak.
Mr. Tudge,
It's my turn to speak. So I'm going to say that this needs to be dismissed because you did not let me show evidence, and then you dismissed the PPO against a dangerous man who admitted to trying to run me over with his vehicle on his documents, and then you dismissed it and turned around and gave him a PPO against me when I was asking him to let me see Haley, who I raised for 5 years, and to get diapers for our babies, who he had abandoned for over a month, and then he kidnapped, and then you facilitated that kidnapping. So you must recuse yourself from this case because you have violated my rights numerous times, and I've asked for a quo warranto. I have asked you to show me your Article 3 oath, and you have refused.